Hello, and welcome to the Federal Labor Relations Authority's virtual training on the 2023 changes to the Negotiability Regulations. In a rulemaking that took effect on October 12, 2023, the authority made a series of changes to its negotiability regulations for the first time since 1999. This webinar will highlight some of the biggest changes, but we encourage parties to read the full updated regulation in the Federal Register. In this training, you will hear from authority attorneys Joshua Brown and me, Tucker Kelleher-Brozost. In the first section of today's webinar, we will cover modifications to the definition of bargaining obligation disputes, as well as changes to the filing and content requirements for an agency's allegation of non-negotiability, and a union's petition and response. In the second section, we will show a brief video explaining when and how unions can separate larger proposals into discrete, smaller proposals for individual consideration. In the final section, we will cover changes to post-petition conferences, agencies' statements of position, and union replies. We will also cover the new definition of administrative resolutions of petitions and other authority actions. Next, we will review the parties' burdens in negotiability disputes and in compliance with negotiability orders. Lastly, we will discuss changes that the authority made and did not make to the compelling need requirement for agency rules. First, let's get started with the definition section found at 5 CFR section 2424.2. In the revised regulations, the authority moved examples of negotiability disputes found throughout the regulations into the definition section. This move did not change the definition of a negotiability dispute. It merely consolidated the definition here for the purpose of creating a convenient list of the circumstances that constitute a negotiability dispute. Some of the most common types of bargaining obligation disputes listed here are matters that are already covered by an agreement, circumstances where there has not been a change to a condition of employment, or there has been a change, but it is de minimis in nature, or where the union attempts bargaining at the wrong level of the agency. For the full list of examples, we encourage parties to consult the electronic CFR, which can be found at the link provided in the description to this video. The authority amended section 2424.10 to provide the contact information for the authority's Collaboration and Alternative Dispute Resolution Office, or CADRO. Although parties could always reach out to CADRO, this change merely clarified that reaching out to CADRO is an option and provided that contact information. The authority amended 3 subsections of section 2424.11, which covers the parties' obligations concerning allegations of non-negotiability. In subsection A, the authority clarified that an agency's obligation to provide a written allegation of non-negotiability is triggered by the union providing a request for that allegation in writing. Agencies may respond to union requests that are not in writing, but this is considered an unrequested allegation. Subsection B provides that agencies have 10 days to respond to a written request. If the agency does not do so within 10 days, the union may file a petition for review at any time. Subsection C explains that if the agency provides an unrequested written allegation of non-negotiability, the union may file a petition or continue bargaining and subsequently request a written allegation. However, if the union chooses to file a petition based on an unrequested allegation, then the union is bound by the same time limits that applies to a requested allegation and must file within 15 days of receiving that unrequested allegation. Under section 2424.21a, the authority left the union's petition filing deadline unaltered. The union has 15 days to file its petition after receiving the agency's allegation of non-negotiability. As I noted in the last slide, if the agency does not file its allegation of non-negotiability within 10 days of receiving the union's written request, then the union may file its petition at any time. However, the authority amended subsection B1 to provide that if the agency misses the 10-day deadline but responds before the union files its petition, the regular deadline applies to the union, and it must file within 15 days of receiving the late allegation.
In order to give you a preview of the various milestones in a typical negotiability proceeding, here we have a timeline. The proceeding begins when the union files its petition for review. Then, the authority typically schedules the post-petition conference. Although the authority will endeavor to schedule the conference before the filing of the statement of position, this does not occur in every case. Next will be the agency's filing of its statement of position. The union will then have an opportunity to file its response to the agency statement of position. And last in the filing sequence will be the agency's reply to the union's response. Both of the union's filings have undergone changes as a result of the recent regulatory revisions. The first change we'll discuss is in section 2424.22 concerning the union's petition. A new subsection has been added entitled Divisions. Divisions explains how the union can separate distinct matters into separate proposals or provisions in order to seek distinct negotiability determinations from the authority on those separate proposals or provisions. Divisions will be discussed further in the animated video we're about to show. The section of the regulation regarding petitions has also been amended to state that the union must explain how the authorities it relies upon relate to the union's arguments, proposals, or provisions. The union is also expected to provide any documents relevant to directly related proceedings, such as ULP proceedings, proceedings before FISIP, court proceedings, or another directly related petition for review. Finally, if the union wishes to seek a hearing in its petition, then the union must acknowledge that the authority rarely grants hearing requests. Turning to section 2424.25, we have the union's response. Severance will still be part of the response under the revised regulations, but it will work a bit differently than it used to. Now, the union may accomplish severance of its own accord without the authority's permission, but the union must satisfy certain burdens in order to prevent the authority from dismissing the union's proposals or provisions due to the lack of an adequate record to render a negotiability determination. Severance will also be discussed further in the video that we're about to show. In addition, the section regarding the union's response has been amended to say that the union must explain the relevance of any of the authorities it relies upon in its response. Now we're about to take a look at the video that I mentioned earlier. The video will explain how the authority resolves a petition according to the union's divisions, but it will also explain how the union may sever previously submitted proposals or provisions in its response. Let's take a look at the video.
Hi, I'm Tucker Kelleher-Brozost.
And I'm Joshua Brown. This video explains the two ways the authority permits unions to separate their proposals or provisions into distinct parts for purposes of resolving negotiability disputes. The authority considers the negotiability of separated proposals or provisions independently from one another.
The first way to separate is to divide the proposal or provision when the union files its petition for review. The second way is to sever the proposal or provision when the union files a response to the agency's statement of position.
To illustrate these two separation methods, I'll play the role of an agency official.
And I'll play the role of a union representative. Let's get started.
During negotiations to reach collective bargaining agreements, unions sometimes propose terms that we, as agency officials, don't think the law requires us to negotiate. When we say at the bargaining table that the agency is not legally required to negotiate certain terms, those terms are called proposals in a negotiability dispute. On our own, or at the union's request, we will provide the union a written allegation of non-negotiability concerning those specific proposals. When agency and union negotiators execute a collective bargaining agreement, the agreement is sent to the head of the agency for a legal review. If the agency head believes that some of the agreement's terms are unlawful, then the agency head disapproves the agreement. Terms that are disapproved on agency head review are called provisions in a negotiability dispute. Now, Tucker will explain how the union separates proposals or provisions into distinct parts.
The agency just sent me its written allegation of non-negotiability. I am confident that 3 sentences in my proposal are negotiable. But I am starting to think that the agency might be right about 2 sentences being non-negotiable. I don't want the authority to find that this whole proposal is non-negotiable just because of 1 or 2 sentences. I know, I'll divide this proposal into pieces so that the authority considers the pieces separately. I don't have to ask the authority or the agency for permission to separate my longer proposal into several shorter proposals. All I have to do is put the separate sentences into my negotiability petition and label them as distinct proposals, with explanations for each sentence. Then I submit my petition to the authority. I could also do the same thing in a case involving provisions rather than proposals. But if I don't divide the proposal when I file the petition, the authority gives me one more opportunity to separate it. Let's say that I have submitted my longer proposal in the petition just like it was written at the bargaining table, with all 5 sentences together.
And let's say that I have already filed the agency statement of position with the authority.
At this point, after receiving the agency's statement of position, I have another chance to separate the proposal into distinct parts. When I file the union's response to the agency's statement of position, I can sever the larger proposal into multiple smaller proposals. The same process would apply to a case involving a provision. Severance is a little different from dividing the proposals in the petition. I can still separate matters by myself, without permission from the authority or the agency, but I need to provide information about how I'm accomplishing severance. First, I need to identify the larger proposal I am severing and provide the exact wording of the newly severed smaller proposals. Second, I need to explain how the severed proposals stand alone with independent meaning and how the severed proposals would operate. Third, I need to explain why the authority should find the severed proposals negotiable or lawful despite the agency's arguments to the contrary. I'm working with proposals here, but I would follow the same steps to sever a longer provision into multiple shorter provisions. Following submission, the authority will then consider the negotiability of the severed proposals or provisions independently.
After receiving the union's response, the agency has a chance to reply to any new assertions from the union. That means my reply can include arguments about any newly severed proposals or provisions. However, I won't offer arguments that oppose severance because the union does not need permission to sever its proposals or provisions. But I can argue in my reply that the union has not sufficiently explained the meaning of any severed proposals or provisions. I can also argue that, even after severance, the severed proposals are outside the duty to bargain or the severed provisions are illegal. Now we wait for the authority's decision. Welcome back from the video. Now we're going to discuss section 2424.23 concerning post-petition conferences. This section has been amended so that it says that the authority will schedule the post-petition conference as soon as practicable. There's no longer a set number of days after the filing of the petition during which the authority states that the post-petition conference will be scheduled. The authority will always try to schedule the post-petition conference before the filing of the statement of position. However, that will not always be practicable, and the parties are responsible for meeting all of their filing deadlines, regardless of whether a post-petition conference is scheduled or may be scheduled. During the post-petition conference, the parties are responsible for informing the authority about the status of any proceedings that are directly related to the petition. And in addition, the regulation has been amended to clarify that the authority may hold a hearing or take other appropriate action in addition to or instead of scheduling a post-petition conference in a particular case.
Section 2424.24 concerns an agency's statement of position and contains the content requirements, the obligation to inform the authority of related matters, and filing deadlines. Regarding content, the agency is required to clearly explain its negotiability and bargaining obligation arguments with citations to supporting authorities. However, the agency cannot simply cite a statute or authority decision. It must also explain why those authorities support its argument. The authority provided that an agency must also include documents concerning any related proceedings, including grievances, unfair labor practice charges, federal service impasse panel cases, or other petitions for review. The authority also removed the section explaining that it is the agency's obligation to contest severance. As we saw in the video, agencies will no longer contest severance in their statement of position. However, if the agency believes that a union's proposal or provision, as divided in its petition, does not have independent meaning or is not sufficiently explained, then it may still raise those arguments. Regarding filing deadlines, the authority left the existing deadline in place. The agency has 30 days from receiving the union's petition for review to file a statement of position. Finally, the authority amended subsection C4 to clarify that while the agency can request a hearing, the authority rarely grants such requests. Under section 2424.26, the authority amended the agency's filing obligations for its reply. Under subsection B of the amended regulations, the reply is due within 15 days of the agency receiving the union's response. Under subsection C, the authority clarified that the agency must explain its position on any arguments the union raised for the first time in its response. The agency must cite to any supporting authority and explain the relevance of that case or law to the agency's argument. The authority also removed the previous subsection D concerning severance. The agency should no longer contest severance because the union can unilaterally sever its proposal in the response. However, as we discussed in 2424.24, the agency can still argue that the proposal or provision as severed does not have independent meaning.
Section 2424.30 has been amended in two ways. First, it now includes a definition of the phrase administrative resolution. This definition is relevant in cases where a union files a petition for review, but there is already pending an existing directly related ULP grievance. Under those circumstances, the authority will dismiss the petition for review without prejudice, pending the administrative resolution of the ULP grievance. Subsection B2 has also been amended. It no longer states that the authority will provide formal notice to the union of a potential opportunity to file a ULP charge or ULP grievance where the union's petition for review includes bargaining obligation claims. However, notwithstanding the absence of formal notice, the union may nevertheless have an opportunity to file a ULP charge or ULP grievance concerning bargaining obligation issues raised in its petition for review. Section 2424.31 has been amended with a new title. The section is now called Hearings and Other Appropriate Action. The authority renamed this section in order to indicate that it dealt not only with hearings, but with other appropriate action by the authority as well. Hearings and other appropriate action may be used to resolve disputed issues of material fact, or when they would otherwise aid the authority in its decision-making. Section 2424.32 has been amended to include a revised subsection C. Subsection C details each party's responsibility to sufficiently explain its position. A party's explanations must enable the authority to understand the party's position on the meaning, operation, and effects of a proposal or provision, as well as the associated legal implications. A party's failure to satisfy its responsibility to sufficiently explain may lead to an authority decision that is adverse to the party. Because of the addition of this revised subsection C, former subsection C has been redesignated subsection D, and former subsection D has been redesignated subsection E. The proposed regulations included a change to section 2424.41 regarding compliance. Under the proposed regulations, a union would have to notify a regional director about an agency's non-compliance with the negotiability order within 60 days of the expiration of the deadline for the agency to appeal that negotiability order to court. But the final rule maintains the existing regulatory wording, under which a union must notify a regional director of an agency's non-compliance within a reasonable period of time after the expiration of the court appeal deadline.
The authority proposed three changes to section 2424.50. This section concerns when an agency rule is supported by a compelling need that renders a conflicting proposal or provision non-negotiable. In the introductory section, the authority proposed amending the regulation to clarify that a rule or regulation may be supported by a compelling need when it is issued by the agency or any primary national subdivision of the agency. With this change, the authority amended the regulation to mirror the statutory definition in 5 U.S.C. section 7117A3. The authority adopted this rule as proposed. The authority also proposed wording that would have recognized the ability of the authority to determine that a compelling need exists apart from satisfying the illustrative criteria in this section. However, the final rule does not include that wording. Finally, the authority requested additional examples of illustrative criteria from the labor management community. However, the authority decided to retain the existing examples without adding any criteria to the list.
In conclusion, all of the changes that Tucker and I have discussed with you were designed by the authority to help streamline the negotiability appeals process and to offer useful clarifications. We hope that together with this webinar, the changes prove useful to you, our parties, and we thank you for joining us.